The Constitutional Court has handed down a judgment which has declared it unconstitutional for private schools to terminate a contract with parents. They're now required to allow parents the opportunity to make representations on the impact of the school's decision on their children. Wednesday's Constitutional Court proceedings involved a dispute between the parents of pupils and the upmarket Pridwin Preparatory School in Johannesburg. The school had expelled the children on the basis of a clause in its contract which allowed it to terminate the agreement for any reason. Justice Leona Theron said that by expelling the children without a clear reason, the school had infringed on their rights to basic education.
Pridwin has not demonstrated that there was appropriate justification for summarily limiting the rights to a basic education enjoyed by the two children. The second judgment concludes that the decision to terminate the parent contracts, absent the provision of an opportunity to make representations on the best interests of the children, is constitutionally invalid. The fourth judgment, compared by Kampepe J and concurred in by Jafta J, Ledwaba AJ, Madlanga J, Mtlantla J, and myself, seeks to emphasize the independent and self-standing rights of the children in this matter. It notes that Section 28.2, that the Section 28.2 standard of the best interest of the child includes a procedural right of children to be heard and participate in the decision affecting their lives.
Senior political reporter Ziyanda Ngcobo was at the Constitutional Court where she spoke to Equal Education about its role in what has been declared a court victory.
The matter started off in the High Court where it was dismissed. It was then at the Supreme Court of Appeal in 2018 which also dismissed the matter. But the parents of those two children still brought the matter to the Constitutional Court alongside Equal Education to have that particular clause declared unconstitutional. Of course, we've gotten the ruling and the judgment this morning. And joining me now is Equal Education's head of organizing in Gauteng, Zamo Mthunzi. Thank you so much for your time. What does the judgment mean for the conduct of independent schools going forward now?
I think it's a very positive judgment coming from the ConCourt. We think always, as this case started long ago, that private schools can make commercial contracts with learners which infringe on the basic, the right to basic education for the learners. And we think the Constitutional Court has come to our understanding and agreement that these contracts, most of the time, of these elite schools that are also growing in provinces like Gauteng, do infringe in the basic right of education to learners, especially to parents who come from working class and poor backgrounds, who struggle with these contracts, who struggle sometimes to make payments for the learners. And we believe that the Constitutional Court has taken the right decision on this matter.
I mean, one of the things that was spoken about also by Justice Leona Theron this morning in her judgment was the fact that even the child themselves in Judgment 4 will also be able to make representations either themselves or through a social worker, for an example. How important is that in terms of protecting the rights of the child themselves and them being given a voice to say if the contract is terminated, this will be the impact on their lives?
Well, we think that learners always have a right to representation, and we believe that learners must always be given an opportunity to defend their right to education, and that's why we exist as Equal Education. I think the court made a right decision to say that the representation must be allowed, because what has happened with the private schools is that because they are unregulated, they mostly take these decisions and make the contracts that are not verified by any law and are contravening the constitution of the country, and we think that's wrong.